Good afternoon, everyone, and welcome to today's webinar hosted by the Department of Justice Elder Justice Initiative, Untangling Power of Attorney Abuse, Equipping Law Enforcement for Effective Response. First, we have a couple of housekeeping items that I'd like to go over with you. Today's webinar will be recorded. You'll be provided with the information from the webinar on the EJI, the Elder Justice Initiative website. All attendees will enter the webinar in listen-only mode. You will not be able to unmute yourself or turn on your camera. If you have any questions for the presenters, please go ahead and type them in the chat box. We will do our best to address them during the webinar, but if we cannot, they will be addressed during the Q&A session before we conclude the webinar. Closed captioning is available via the Show Captions button at the bottom of your Zoom screens. And we just want to give a big shout out and thank you to our ASL interpreters today, Jessica and Erica. Now I will pass it over to Chantel Smith from the EJI to get us started.
Hi, everybody. Welcome. Thank you for being here. Thanks for taking the time to join us today on what I think is a very important topic, and I'm looking forward to hearing from some of you and hearing your thoughts as well. A little background about the Elder Justice Initiative. It is a Department of Justice initiative, and its goal is to combat elder abuse, neglect, and financial frauds and scams targeting older adults in this country. The initiative works by promoting justice for older adults. That is the main goal of EJI. We also provide help and support for victims and families. And another major goal of EJI is to support state and local efforts by providing training and resources and other forms of support, and also to do research on policy and practice in the elder abuse world. Next slide, please. You can see here as a basic outline of the EJI website. If you've not been there, I encourage you to go there. We are always looking to improve it. We are updating it. It is for you. So if there are things that you don't see on there that you'd like to see, please let us know. I dropped my email in the chat box, so you have it anytime. Reach out, let me know if you see something that needs to be changed or that needs to be added. Fair game. You'll see we have some outreach on there. We've got videos for prosecutors, which we are working on and adding to. We've got elder abuse research, so plenty of topics. The MDT guide and toolkit is there. Talitha Gwynn Shaver is one of the country's premier experts on MDTs and is always available to answer questions and provide guidance. There's information about financial exploitation and reporting. We've got past webinars, and we have elder abuse statutes there, which we are also updating. And next slide ties to EAGLE, which is the Elder Abuse Guide for Law Enforcement. If you have not been out to look at EAGLE, I highly recommend that you take a look at it, whether you're law enforcement, prosecutor, or other. It's got lots of good information on it. It's directed at law enforcement, but there's plenty of information there that's helpful to all. You'll see there are checklists, roll call videos. The state-specific laws or the statutes, that's where we will be updating them primarily. So if you want to see what other states are doing, that will be the place to go. There's also training specific to law enforcement on there. This slide is here because the email address for EAGLE is on there. If you've got questions, feedback for them, email them. They're happy to take a listen. Also the website and Twitter handle there. Next slide, please. This is also EAGLE. Again, there's your code to scan, get you right there, and the email address. The purpose of this website is to provide tools to help law enforcement protect older adults. But again, lots of information for lots of people. So please do take a look. And one more slide on EAGLE. This is what it looks like, just to give you a picture. This is the homepage. Easy to access. You'll see the state statutes at the top and other information for law enforcement there. You'll also see on this slide that there are documentation checklists, which are very helpful to law enforcement and others, and also community resource referral information. So again, I urge you to take a look at EAGLE. Next slide, please. We have our presenters today. We have Katie Walker, who is an assistant special agent in charge of the Georgia Bureau of Investigation Gang Task Force. Makes her, I think, supremely interesting in this conversation. You think, what does this person who is on the Gang Task Force have to do with elder abuse and POAs? You'll find out. We're very appreciative for both Katie and Will for being here today. Some hard times in Georgia lately, and I know Katie was on the scene yesterday of the shooting, so we appreciate you taking your time being here. Will is a prosecutor, highly experienced prosecutor in elder abuse. He is with the Prosecuting Attorneys Council of Georgia. He specializes in adult abuse and is also a juvenile court prosecutor in Georgia. We thank you both again for being here, and we look forward to learning from you. Next slide, please. Our agenda or objectives, if you will, so that we've got a little bit of a roadmap here today. We're going to talk about the definition and legal scope of POA abuse, basic level here. So not law school level, that would probably bore all of us, but the basics. We're also going to talk about the key elements of a POA abuse through a case study. We'll talk about the investigative process. Again, you're hearing from someone on the Gang Task Force talk about investigating an abuse case. We're going to talk about challenges in investigating and prosecuting these cases. Again, we'll look at a case study. We'll talk a little bit about collaboration amongst law enforcement, prosecutors, providers, in particular medical providers. And we'll talk about building a POA case and some of the issues that come up in prosecuting these cases. Next slide, please. All right, so starting with Will. Will, can you walk us through just a bit about the basics of a POA?
Absolutely, and thank you all for being a part of this afternoon, and thank you to all who've made this possible. So what is a power of attorney? I'm going to editorialize slightly. I always joke in my trainings that I absolutely hate a power of attorney because it is so possible for abuses and problems to happen, and I see it frequently in my cases. The document provides that an individual who is the principal, gives one or more persons, who can be called an agent or attorney in fact, the power to act on that principal individual's behalf. So it can cover medical, financial, health. It can be triggered by a specific event, such as a springing power of attorney. For instance, if someone is going to have a major surgery and will be in extensive recovery, they may need someone to handle their business during those times. It can also continue after the principal is incapacitated. Typically, a power of attorney is used in cases where a loved one is declining, unable to properly take care of finances or understand and make decisions for themselves. It's a document that provides that kind of assistance to this person so that someone in the family, a trusted person, can step in and help them with decision-making ability. The problem is the breadth. It can be very specific and limited powers in a power of attorney, or it can be as broad as possible, giving carte blanche ability for decision-making and power over this person who is the principal. Next slide, please. So there are a few examples of powers that are possible under a power of attorney. On the financial side, it can allow for banking, paying bills, withdrawing money, purchasing or selling property and assets, gifts or loans, to manage a business if this individual who's struggling owns some kind of business, personal or family maintenance, and to file and resolve lawsuits, especially where someone is struggling cognitively with the ability to follow the complexity of a lawsuit. On the healthcare side, it can provide access, full access to medical records, consent to disclosure of medical information, how to make or allows for making healthcare decisions, determining daily care and treatment of a person. And it gets a little more dicey because it can provide the agent with the ability to place someone in a facility or some kind of home health care situation, and it can allow consent to organ donation. Next slide. So there are a few pitfalls of a power of attorney. And the first is that there's not really extensive oversight. I've done a quick survey of a number of states, and the general consensus is that a power of attorney tends to be between the principal and the agent. And there's not a lot of oversight by third-party entities. It keeps things more in a family or trusted person's network. Power of attorneys can also create a little bit of instability. I know in Georgia, the way you revoke a power of attorney is the principal just signs, I want it revoked. And so it can allow for changing. In fact, I handled a case where in the span of a year, on a victim, there were 4 power of attorneys filed or written out and notarized. It creates the potential for abuse. In most instances, the vast majority, the person who becomes the agent and provides care for this principal is a trusted person who will love them and take care of them. But it can also be a little bit nefarious because someone who has greedy motives or bad motives can come in and take over and access extensive savings and finances, can put a person who's health-wise not prepared or ready yet for skilled nursing in some kind of facility. It grants powers that could be very difficult to, or very easy to abuse, either very directly and pointedly or indirectly if you have someone with caregiver fatigue or burnout or struggles such as that without much help. It allows very expansive access. And in some states, and I know in Georgia until recently, the power of attorney didn't even have to be notarized. And so it was just this kind of this document out there that allowed for expansive access to a person, their resources, and their physical well-being. It's also difficult because the person who is the principal can have dementia or cognitive issues while signing. Whereas in testamentary documents, such as a will, there has to be some attesting that this person has capacity to sign and agree on these documents. In many of the cases where I've seen abuses of the power of attorney, the person who was the principal, who was the subject of the power of attorney, already had some major dementia and cognitive issues. And there were a lot of questions about whether this person had the capability to consent to what was being done. Next slide, please. There are a number of ways that a power of attorney can be criminally abused. Now, I want to take this out of the realm of civil. We're not talking about a civil dispute here. We're not talking about a quibble over an extra $50 at Walmart. We are talking about criminally using a power of attorney to commit exploitation.
Well, let me interrupt you here for a second. Well, why so many times do we see or hear from people saying, I reported this to law enforcement and they said it's a civil matter, I should go get an attorney?
There's a lot of consideration that because most of the power of attorney documents occur within the family dynamic, that this is just a dispute among family members, or that this is really a fight over inheritance documents or bank documents. And I think for two reasons. Number one is a lot of folks don't understand that what they're looking at is criminal. They think it's just two people fighting over a little bit of money and how it was spent, or the sheer ability to investigate a financial case with limited resources. And they may believe it's easier to go the civil route than the criminal route.
And it's possible for it to be both, right? It can be both civil and criminal.
It absolutely is. At the end of the day, if someone commits a financial crime, you can also sue them for the civil damages on that. There are a number of types of abuse around a power of attorney. Financial exploitation is the top one. Obviously, if someone with bad motives is seeking a power of attorney, the root of all evil on this is greed. Theft or fraud can be very common as well. Breach of a fiduciary duty. Very often, a power of attorney creates what's called a fiduciary relationship, where someone is bound financially to be responsible for another. And in the law, when you breach that, we call it breach of a fiduciary duty. That's pretty common in contractual law, probate law, and criminal law. Emotional abuse can also be common, and neglect and physical abuse, especially if you have someone suffering from caregiver fatigue for a principal who is requiring a lot of care and assistance. And in some cases, it can lead to murder, because you can have someone who is so isolated, no one sees that they were overdosed. Or if they are in some kind of medical situation where their wishes might have been, I want all resuscitative means, the principal or the agent can say, well, I don't care what they wanted. I have the power of attorney. Pull the plug. They're done. Next slide.
Katie, this is where we're welcoming Katie back to the screen, and she's going to walk us through her case study, kind of the basics of it, and then we'll get into the meat of it. We have taken, as you can see, names out of here. So if it gets a little confusing as to who is who, just flag it and we'll have Katie clarify.
Hey y'all, thanks for having me on today. I am coming to you from Athens, Georgia, so I do want to say go Dogs before we get started. And as we talked about before the presentation, Will is a Wildcat. So we're in the middle of football season here and very excited about it. As I mentioned, I'm working a gang unit, so I am more of a gang specialist. I have very little experience and or training in elder abuse cases, but I do want to talk to you about a case that I got involved in as a part of the GBI. So before I moved to the gang unit, I was in just a regular field office, and the GBI, we're state police officers, and we get requested. We have to be requested. So if someone calls 911, we would not be a first responder to any sort of incident. So in order for me or any other special agent to be involved in an investigation, we have to be requested by someone in authority. That would be a chief, a sheriff, a district attorney, solicitor, a judge. So in this particular case that I'm going to talk to you about, I got requested from a sheriff's office. And it is a bit confusing with not being able to give names of people. So I'm going to do my best. If you get confused, please let me know and I'll try to clarify what I can. So essentially, I had an 82-year-old victim, and she, for all intents and purposes, had a clean bill of health, except for she had a knee injury and she was awaiting a knee replacement surgery. And during that time, she had multiple children, adult children, and adult grandchildren. And she, while awaiting that knee surgery, she contracted the flu. So her eldest daughter, who is the suspect in this case, and then another one of her daughters, who I'll say, we'll call her caretaker daughter, took her to her primary care physician. And during that visit, that doctor's visit, the suspect daughter and the primary care physician, after the exam, left the room. And when the two of them came back into the room, the doctor let the primary care daughter know that he was recommending the victim for hospice care. She had never had any other thing in her medical history that would lead this caretaker daughter to assume that coming to the doctor today for the flu would put her mom in hospice care. So I do want to point out that the suspect daughter, worked for a hospice company. She worked for a hospice organization. So at some point when the two of them left the room, that conversation happened. When they came back, the suspect daughter, promoted her company, said, we would like to take care, be the caretaker for my mom during this time. And so that's sort of how the victim got put into hospice care. So the victim left the primary care physician's visit that day. She went back to the caretaker daughter's home, and she was cared for probably 3 to 4 weeks. And essentially all the hospice company did in that time was they provided her with a bed that they placed at the house, some diapers, some medication, things like that. She was never seen. The victim was never seen by a physician associated with the hospice company. She was only visited once a week by a nurse, and she had someone come, I think, daily or every other day to give her a bath. That was the extent that this hospice company that her suspect daughter was involved in had in her care. So the primary care daughter had a family wedding to attend. I think it was her stepson. So that was known to the other family members. Hey, I'm going to need to be out of town this weekend. And so primary care daughter leaves town. Suspect daughter comes in and assumes care of their mother. So I do need to back up and say, though, from the first slide, I'm sorry, I'm jumping around, that the day that she was placed on hospice care, suspect daughter and caretaker daughter assumed power of attorney over their mother. So she had an original power of attorney document that was signed by the victim and 2 of her other children. And it was a lengthy 13-page document that had a lot of specific elements to it, where the victim specifically initialed certain things that she wanted. She sort of handpicked her care of what she wished for. The new power of attorney document that came into play the day that she was put on hospice, that the suspect signed, was a 2-page document. And I'll talk more about those documents a little later in the presentation. So back to, we get the victim home, and the suspect daughter has now taken over her care. In that probably 3-week time period that she had already been on hospice, she had not required any strong medications, no opiates, nothing that would indicate that she was near end of life. And her primary care physician also told her when he put her on hospice care that he believed that she had 6 months to live at 82 years old. So the suspect daughter assumes care, and the day that she responded to the house to start taking care, she immediately called the physician at the hospice company and said, my mom needs morphine and fentanyl patches. The doctor, again, making no physical visit. He doesn't make a FaceTime visit. He does not see the victim at all, assigns her prescriptions. The suspect daughter's husband goes and picks them up, brings them back. At one point, the suspect daughter had placed 3 fentanyl patches on the victim at one time, and she administered at minimum probably 100 milliliters of morphine to the victim. I'm not a doctor. I can't begin to understand all the things about hospice and end-of-life care, things like that, but I do know that she was administered a large amount of medication. She was opiate naive. She had never received any of these medications before for her knee injury, for any other thing that she had had in her past. So the suspect daughter begins to administer that medication, and she goes downhill very quickly. The mother does. And to the point that the family is starting to be suspicious. Why is this going on? Why is mom all of a sudden nosediving? Why do you keep giving her medication? And the suspect daughter was administering probably about a milliliter of morphine into her mother's mouth every 10 to 15 minutes. She was writing a log of this so that she could keep up with how much medication she was administering, which became a key piece of evidence for us in court. Because I believe the typical recommended dose of morphine is probably 0.25 milliliters, like every 2 hours. So she was pumping her very quickly with medication that she didn't need. Yes, I'm sorry, I do see a couple things. Suspect daughter has no medical training. Her job at the hospice company is a clerical, human resources, front desk kind of lady. She has absolutely no medical background and no medical training whatsoever. She also is administering this medication. Now, once the mother starts declining, the family calls the hospice nurse to come to the house. Hey, mom's really taking a nosedive. We need you to come see what's going on. And suspect daughter refuses to let the nurse then administer medication. Suspect daughter says, I'm the only one that can do it. You know, I'm in control here. I'm in charge here. So all of that leads to the mother, the victim. Finally, she has 5 or 6 kids, I can't remember now, that are there. They start to come back to the house like, hey, if mom's about to die, we all kind of want to say goodbye. We want to be with her in her last moments. And new power of attorney, suspect daughter, who's administering the medication, it starts demanding that the previous power of attorneys produce their mother's will so that she can go ahead and get affairs in order. She's 100% planning for and anticipating her mother's death at her hand, obviously. And the children, the adult children, kind of come to blows a little bit. There's lots of arguing. The suspect daughter, again, no medical training, is diagnosing her mother now with kidney failure, saying this is, you know, why she's having all these other symptoms, and this is why I need to continue to give her medication and give her this specific medication. So finally, the oldest son is like, I've had enough. We're not doing this. I'm calling a friend of mine in the community who is the coroner here at the local coroner in that county. So he makes that phone call. The coroner is understanding the situation. It's kind of hostile at the house. There's a lot of arguing going on. So the coroner then calls the sheriff's office to respond to the residents with her. She doesn't feel safe going there in case a fight breaks out between the family members. So the sheriff's office then gets involved. Once they are involved and the victim is transported to the hospital, that's when they requested the assistance of the GBI. So the victim gets to the hospital and the doctor tells me that she essentially is in a medically induced coma, that she has nearly been overdosed during the last probably 48 hours. And again, just to reiterate, she was opiate naive. She had never had the fentanyl or the morphine or Ativan or Valium, any of that before 2 days before when her suspect daughter began taking over her physical care. I think we go to the next slide. So the suspect daughter, another thing, when they started calling the family in, the victim, 82 years old, had 2 living brothers that were still alive. They came to visit her. She begins to plead with her brothers, make suspect daughter stop administering this medicine to me, make her stop giving it to me. I don't want any more of it. They feel like they don't have any power because suspect daughter is sort of running the show. She's will not let anyone into the room with the victim without her being in there. She's demanding the will, things like that. And I will say that suspect daughter did have a very extensive criminal history. It was not violent at all. It was all fraudulent crimes, financial crimes, fraudulent documents, white collar type things. So just something to keep in mind. She didn't have any, very recent crimes, but she did have a lengthy history of criminal activity. Next slide, please. So a couple things about the power of attorney. Like I said before, the original power of attorney was very lengthy. It was very detailed. I did not request or use any sort of handwriting analysis expert with this document, but like many of my criminal cases, we try to apply common sense in things that we're looking at. So on that document, the victim's signature was very shaky. It was not completely illegible, but it was not very good. Her signature was not well. I could tell that at her age, probably her ability to hold a pen and her ability to write had declined. And then on this brand new power of attorney that surfaced the day that she got put on hospice care, the signature was pristine, very crisp, very legible. The letters were very normal and nice. So during my crime scene investigation, I found some other documents that had the victim's signature on it. And from previous years, the previous year's signature, I believed, matched this fraudulent fake power of attorney document, almost as if it had been copy and pasted. Now, I will say that the power of attorney document was not a criminal element that I charged in my investigation, but it was a key part of the investigation because it was the springboard, I believe, that the suspect used to assert and gain immediate control over her mother's care. And so she used this fake power of attorney to say, I'm in charge. I get to make all the decisions. I'm going to do whatever I want to do. My company that I work at is going to provide the care. And that's who's going to be running the show from here on out. And I think that the important part of that is it just sort of set her up to be in a position that when her other sister did go out of town, she could use that opportunity to seize complete control and administer whatever medication she had at her disposal through her company, like almost like they were doing her a favor, giving her whatever it is that she wanted so that she could use it however that she wanted. And she obviously used it criminally. The next slide, I believe, is the charges. Yep. So this did not go to a jury trial. It was, we had a bench trial, which means it was just tried in front of a judge. And the things that we tried her on were criminal attempt to commit murder, which she was found guilty of, neglect to a disabled adult, elder person, or resident, which she was found guilty of, aggravated battery, she was found not guilty of. And that was for the way that the suspect daughter administered the morphine. She used it like in a syringe, and she would put it kind of in the pocket of her cheek inside of her mouth, and that caused severe sores, almost like burn sores inside of her mouth. She was not able to swallow even water hardly from that injury inside of her mouth. So that's why we charge aggravated battery and exploitation and intimidation of disabled adult, elder person, or resident. She was found not guilty. Sorry.
So, Katie, when this case came to you, I think you've said pretty explicitly, you are not an expert in this area.
No, ma'am.
And when you and I talked, I asked you, had you seen a POA before? Were you familiar with them?
No,
and
definitely not. I had not had any significant elder abuse cases in all of the crime and things that I had investigated before. So this was my first true elder abuse case. First time I had seen power of attorney documents. The first time I ever had any dealings with hospice in any of my criminal cases, and all of that. I had never had any exposure to prior to this.
A learning experience for you, basically.
Definitely.
But what made you take this case or move forward with it?
So I would say that, the one, I'm not really allowed to say no to cases that we would get requested for, but there is a certain level of how much work do I put into it versus how much do I not. And I would say that the victim in this case Very, very incredibly sweet lady, who 100% was taken advantage of by her daughter. And the situation was very complicated and very messy because of all of the other children involved and the emotions and the family dynamics and things like that that kind of all played into it. And it being a difficult thing for her, the victim and her family, to sort of wrap their minds around the fact that their sister or their mom tried to kill their grandma, or sort of the head female of their family, their matriarch. And she did it in what she thought was the best manipulative, most disguised way, but she definitely tried to kill her mom. And she used her position that she was put in with this hospice agency, you know, to put her to set her up so that she could take advantage of this. And I would just say that the victim, who absolutely, I mean, she's wheelchair bound because of her knee. She had no ability to fight this on her own. And with the emotions and things of the family around her, she probably really didn't even have, it just was complicated. So for me to be able to come in and say, this is what's black and white, this is what we know as truth, and this is what we can prove, and this is what's probable in this situation, this is where we're at with probable cause, she was just worth fighting for. She was worth going through the extensive effort that it took for me to understand all the different elements of these type crimes and these type cases that I didn't know about before, and to use that to her betterment. I'm going to tell you, based on all of the things that, I mean, her doctor giving her 6 months to live and putting her on hospice essentially for no reason, and then she survives a drug overdose and a hospitalization. And then it was assumed that the victim would not even make it to trial. We all know nothing goes to trial 4 months after we start the investigation, when everything is fresh and details are current. So the victim was actually deposed because it was assumed that she wouldn't make it till whenever the trial occurred. And I'm here to tell you, this case happened in 2017, and my victim is still alive and well today. So not only did she make it through to trial, where she testified against her daughter, she's still doing great. She way surpassed the 6 months that her primary care physician gave her to live, which thankfully she didn't go back to him. I do also think, this is a random comment, but I thought that her primary care physician received a kickback from the hospice agency for using them as or sort of referral to them.
And did you take any action? There was a question about it, but I know you and I talked about this. What did you do regarding your concerns about the hospice provider?
So the hospice provider and the primary care physician, we don't, or not that I know of, we didn't at the time, I guess, have clear laws on exactly how to handle that with the physicians. But I definitely reported them to, I'm trying to think of the name of the state agency now, but basically our medical board.
Healthcare facility regulation.
Thank you, sir. Yes. Again, not an expert in this area. A lot of new things for me on this one.
And going back to the trial, you said she was deposed early on based on the assumption that she would not make it to the trial date, but was she cooperative? What was your relationship or your interaction with her on that?
Yes, she was very cooperative. She was very emotional, though. I think it took a lot for her to accept the fact that she essentially had to cut her daughter off. There could be no positive relationship from that point forward. And that broke her heart. That was very hard for her to deal with. That was very hard for her to accept and to acknowledge, and then even to testify in a way that, you know, she knew that the outcome of that trial could be that her daughter could go to prison, that her daughter could, you know, receive whatever consequences that the court placed on her. So it was very emotional for her. Again, even by the time she went to trial, she was in her mid-80s, and her cognitive ability, her communication skills, all those things had declined, but she was still able to roll in her wheelchair up to the stand and testify to the judge about what had been done to her. Now, most of the, we'll call it assault, she didn't quite remember. I mean, she was being heavily medicated. There was a bunch of it that she couldn't recall, but that's where that log that the suspect daughter was writing down, hey, 10 minutes later, I gave another milliliter, and, you know, another 10 minutes. She was putting times down, saying how much medication she was administering. So there was no doubt how often and how much she was giving her. And, you know, she was able to take that information and start to sort of wrap her mind around the family dynamic and how she was manipulated and controlled in the situation.
And did her daughter end up serving any jail time?
So, no, she got house arrest, which we fought heavily, but I will say, I don't know how much of this I can articulate professionally, but I will say that the suspect was a very well put together, middle-aged white lady. Her hair was always done perfect. Her makeup was done perfect. And even the two guilty and two not guilty, in my opinion, knowing the judge and having, you know, multiple other trials in front of that judge, I felt like that was the judge's way of like, I'm gonna go right down the middle. This is messy. This involves a lot of family. This involves a lot of emotion. You know, everybody wanted to say, well, this suspect daughter is just a mistake. She didn't have any medical training. How would she know she was giving too much? You know, she didn't know what she was doing, all of those type things. But the reality is that wasn't the reality. She didn't know what she was doing. She requested medication that she should have never had access to. She administered medication that she had no training or knowledge of administering. And, you know, I would say that even to back that up, it's the other actions. It's that she got this fake power of attorney document, that she took her mom to the doctor. She left the room, had the conversation with the doctor outside the room, came back in and said, my company is going to do hospice care for mom now. Those type things. She was in constant manipulation of the system the whole time. And I felt like the judge was like, well, she's not guilty, but she's not fully guilty because this isn't a violent crime. So I'm going to say she's guilty of half these, not guilty of the other half, and we're going to tell her she can never leave her house. It did go to appeals, and our side was upheld. So, you know, at least she didn't get to come off of house arrest, but she's still not a good person. So.
Did you sense that there was a financial motive here, or are we talking about control, both?
So I didn't have any evidence to support that. Her mom did not have a lot of money. So the financial motivation didn't seem logical, but it did seem that suspect daughter, there was a lot of family drama, a lot of family history, a lot of things that kind of played into this, but it seemed to me like the money wasn't the motive. It was the control. It was the power. It was the fact that she could basically stiff it to all of her other siblings. Like, I'm the one that did this. I'm the one in charge. I'm the one that's doing that, like finalizing mom. I am the end of, period. Like, she seemed to me like she just needed to be the one that controlled the entire situation, and so that it would have the outcome that she wanted. Not the best outcome for her mom, obviously, but the one that she could be in control of, so that she could tell her other siblings, like, look, I know what happened in the past, but I got the last word now. So
was there any money taken? Was there any evidence of any exploitation?
No, nothing of significance. I mean, she didn't have really, other than her late husband's Social Security check that she was getting once a month. She really didn't have any finances of, you know, significance.
And did you work with victim advocates in this case? Was there a support system for the victim here?
Yes, there was. Through the district attorney's office, they provided wonderful victim advocate care. in order to help her navigate the court proceedings, the trial process. They coordinated getting a handicap accessible van to her house to pick her up. They coordinated helping build a ramp in front of the caretaker daughter's house so that she could easily get in and out, things like that. They did a lot of that type of care for the victim.
And something that you mentioned to me, I think is important that we forget about how much work you put into just to set up the courtroom so that the victim could testify. Yeah,
this particular courtroom's not new and definitely not accessible to all types of people. So actually the witness stand is a step, and then it actually has like a hump in the trail, I guess, to the bench and the chair where the microphone is. And so we had to essentially scrap that, place the victim somewhere else, and just provide her with a microphone because she was not able to access the normal witness stand.
Well, thank you for doing this case. And we're going to bring Will back in for the next slide, but please don't go away, Katie, to talk about some considerations from the prosecution perspective, but also working with law enforcement on these cases.
Thank you. These cases are often very complex and document heavy. And the first thing you have to look in this consideration is whether this person fits your protected class, an older adult. In Georgia, the statutory language is elder person, disabled adult, or resident of a long-term care facility. You have to assess what is the capacity of your victim. Is this someone who is going to be able to testify? I know Katie talked about they did a deposition because they did not think that the victim would make it until the trial date. There are two ways in Georgia we can do the deposition. It is if someone is quote unquote so sick or infirm that they may not survive until trial, or any material witness over 72 years of age in Georgia, 72 or older. We can do a deposition in case it is needed. You will have to look at the relationship between victim and perpetrator and any financial analysis. If there's a financial motive to these cases, especially if you have a wealthy victim, there can be quite a number of records and documents that need to be assessed in these cases. Next slide. So we talked a little bit about motive, and many of our laws create these different kinds of schemes. So if I'm analyzing it from the perspective of Georgia law, in which I am most versed, we have a number of types of schemes that financial exploitation can include, and that's coercion and duress of the victim. Was there some kind of physical threat or force? Harassment, deception, some kind of false representation, undue influence. We're one of the fewer states that undue influence is codified as a means of exploitation. We also have a unique one called abusive access, which means taking advantage of the proximity and incapacity of the victim. But we also, our legislature was kind enough to include at the end of our definition of exploitation these words, and other such similar means. So next slide, please. And I wanted to talk a little bit about undue influence, because this is the most common way that we see power of attorney abuse occur. I've prosecuted probably 10 or more cases now where a power of attorney was at the heart, and undue influence was present in 9 out of 10. Legally, it's defined as persuasion which overcomes the will without convincing the judgment. And it includes isolation of the victim, dependence upon the perpetrator, emotional manipulation of the victim, and you will have victims that not only accept but fight on the perpetrator's behalf because in essence they are brainwashed. It's rarely detected, it's difficult to investigate, and because of the extensive isolation, it is challenging to prosecute because we're geared towards being victim-centric. And in almost every single undue influence case, you're going to have to prosecute over the will of the victim. Next
So
slide.
Will,
please.
we're talking about an undue influence, those cases where we see the victim saying, no, this is what I wanted. I'm good with this, that kind of language. Is that what we're talking about?
Absolutely. This is the only person who takes care of me. I don't care how much money they take. But I've seen it on the other end of that when the perpetrator disappears and the victim realizes that $350,000 is gone. So one of the ways I've structured in Georgia the charges and how I didn't prosecute Katie's case because I'm a resource prosecutor. I'm not a frontline prosecutor at this point. In our statute, we can charge illegally or improperly using the resources of an elder person, disabled adult, or resident of a long-term care facility. And in our charging language, it says by means of, and then there's this opening, how we describe the means for the profit or advantage of another person. Because of that catch-all in the law, instead of charging undue influence or false pretenses or coercion and trying to make this fit, I've used the catch-all and charged it as by means of power of attorney abuse. So next slide, please. So you would use that charge to tell the story to the jury. Did knowingly and willfully exploit the resources of your victim, a person 65 years of age or older, by means of power of attorney abuse, to wit, and we still use a little legalese in our indictments in Georgia, unfortunately, to wit, I would charge said accused did obtain a power of attorney under the false pretense of assisting the victim with her finances, and then did use that power of attorney to obtain U.S. currency for the profit or advantage of another person. And that way you tell the jury that you're not trying to contrive what happened. Literally, your perpetrator obtained a power of attorney for the purpose of exploiting your victim. Next slide, please. So here are the common defenses that police and prosecutors will get. In every 10 out of 10 cases, they have said, I have a power of attorney, you can't do anything. We thankfully have a statute in Georgia, 165105 in our statute says, the existence of a power of attorney shall not in and of itself absolve someone from prosecution. We will hear this is what the victim...
William, this is the interpreter. Can you repeat that again, please?
Yes. The existence of a power of attorney shall not in and of itself absolve someone from prosecution. So basically, you cannot use the power of attorney as a defense to being charged with the crime. We also hear this is what the victim wanted. This was a gift, I didn't take it. I was going to inherit it anyway. I cannot say how many times I have explained there's no such thing as pre-inheritance. You also have to consider how valid is the power of attorney. If your victim is near comatose or at the advanced stages of dementia, that's not particularly a legitimate power of attorney because the person does not have capacity. The biggest difficulty I see on financial cases is deciphering what was legitimate and what was not, because perpetrators are very good at spending some for the victim, some for themselves, and it blends over. So if you have $600 spent at Walmart, it's difficult sometimes to go through and say, well, this was valid, this was not. Now, if you have a wheelchair-bound victim and you see on the credit card that someone went to a bar in Florida you can make a reasonable assumption that that was not for the profit or advantage of the victim. But that is a common difficulty, is deciphering the validity and legitimacy of the financial payments made. Next slide, please. Oh, well, I guess we're to the questions because that's the notice you can't sue us.
And Will, if we could go back to that prior slide, at least here in Iowa, in my prior work on these cases, I always called it the fainting goats. When somebody appears with the POA, everybody just sort of acts like fainting goats, and they say,
Yes.
oh, I couldn't say anything, I couldn't challenge them because they have the POA. I saw this with financial institutions, I saw this with medical providers, you name it, across the board. And I think, and I'd like you to address this a little bit, I think sometimes there's this perception that the POA gives the agent the power to do anything. They make all the decisions, but that's not true, right?
That's not it. It's really a contract at the heart of it between the principal and the agent, that if the principal is unable to provide and make decisions and manage finances, that the agent will do that on their behalf, and in particular, in the way this victim would have wanted. And so if you have an agent who is violating that trust, violating the wishes of the victim, they're not acting as agent or attorney in fact. They're acting either in a, well, if it's just misuse and mismanagement, then it would be civil. If it's a conspiratorial way of taking money, then it's criminal.
Taking money or harming, physically.
Yeah, taking money
harming.
or harming. Katie's case is a little bit more on the extreme end with the physical harm. Most power of attorney cases are simply a means to get money. But it creates this contract that you will act in the wishes of the principal.
And one of the questions we had was, what are options when valid prior POA needs to be revoked, but principal has since become incapable or impaired, which is something we
saw.
Can
you repeat that? I'm sorry, this is the interpreter. Can you repeat that
yes.
question one more time?
What are options when valid prior POA needs to be revoked, but principal has since become incapable or impaired, which we saw quite frequently and we're sensitive to, is this person is going to lose, we're going to lose this POA. And now we have a person who doesn't have anyone to provide assistance, and they don't have the capacity to sign a POA. Now we're looking at, and here comes the guardianship conservatorship, right? Which is a very extreme and serious restriction of someone's rights. So what do we do? What do you do? What do we do?
Really and truly, in most states, that's about the only other option, is to go through the court system. If a person now lacks capacity to voluntarily do a POA in Georgia, that unless you have a very, very trusted person willing to just take things on and can find an attorney, a probate attorney with enough knowledge of what to do, really and truly the only other step for an incapacitated person is a guardianship conservatorship. And it's probably in general the safest.
Right, until it's not, right? which then is a whole different webinar topic. Yeah. But that's where we land, right? Is we have a lot of people too who don't have anybody, right? That their son who was exploiting them or harming them was the only person in their life. And now we're saying, you can't do that anymore. We're putting you in jail or otherwise. And now we have people who have no one.
Yes.
I assume you see that as well. Yes. And in some states, there are substitute decision makers at the state level to step in, but those are few and far between, and difficult to access in my experience.
Yes.
I think we have one more minute. So there's a question about, was the undue influence prosecuted civilly or criminally? I will say from my end, we don't have undue influence, or you don't see it very often in states where undue influence can be a criminal violation in and of itself. But
Mhm.
what do you see, Will?
So undue influence is one of those weird ones that crosses both civil and criminal. I've charged it in criminal cases, but I've also seen probate cases in Georgia where undue influence was at the heart of the probate case or civil case. It grew out of civil law, but in Georgia, we saw it so much that when we did the tremendous overhaul on our laws in 2012, 2013, it was added as a means of exploitation because it was so common to see someone who had great access to a victim push and overcome that victim's will, even though what they were doing was not the best decision or the right judgment, if you will.
Well, I see that we are bumped up on time, and there are a few more questions which we can address outside of the webinar. Again, my email is included in this chain. Any questions for me, Will, Katie, let us know, and we truly appreciate you being here today, and look forward to seeing you at future webinars and conferences.
Thank you all.
Thank you, everyone. And we just have an evaluation for our webinar today. If you would like to take the evaluation, you can open the camera app in your phone to scan the QR code, click the link to the survey that pops up on your phone, and then take that survey. Thank you so much, everyone.
Thanks. Bye, y'all.